Good morning, ladies and gentlemen. My name is Dick Wright, as I mentioned previously, and I'm the chairman of the Shasta County Coordination Committee. This committee has been in existence for approximately 4 years and was formed at the behest of one of our members, Sylvia Milligan, who had met Fred Kelly Grant and learned of the existence of the process known as coordination. We are an all-volunteer group of citizens from varied backgrounds, many with direct knowledge of land use issues, water issues, forest issues, and the local economy. We are committed to assisting local government agencies in Shasta County in the use and practice of coordination. Coordination enables local governments to deal on a level playing field with federal and state agencies who all too often issue regulations that negatively affect the health, safety, welfare, and economy of the county. Our committee focused initially on issues dealing with the Forest Service and BLM, specifically issues dealing with road closures in the Shasta Trinity National Forest. We worked in conjunction with the County of Shasta and were successful in keeping all of the roads in the forest open to the public, their rightful owner. In August of 2013, the City of Redding came to the committee to ask whether the diesel particulate filter rules issued by CARB were subject to coordination. The committee agreed to research the issue and advise the City Council of our findings. The results of our research were presented to the city, and the city subsequently passed a resolution invoking coordination with CARB. Since the passage of the resolution, the city has repeatedly requested that CARB fulfill their legal obligation to coordinate. To date, CARB has not coordinated with the city and, in fact, maintain that they are not subject to coordination. We are therefore here today to right the record, and as our counselor, Mr. Fred Kelly Grant, will ably explain. Thank you.
Thank you, Mr. Chairman. Mr. Grant, would you like to proceed?
I think that's on now. I want to explain to the board members the law that we will be applying at the end of this hearing to ask you for relief against the United States Environmental Protection Agency and its consolidating, cooperating agency in California, the California Air Resources Board, also known as CARB. Coordination is a process that was established by the Congress of the United States. It was established when the National Environmental Policy Act was passed in 1969, and that statute requires that federal agencies coordinate in their planning and in their processing and rulemaking with local governments. That statute was passed at the time that the administration was beginning to discuss the sale of the the retention of the western lands. Until that time, throughout history, the policy of the United States government was to sell all the western public lands. And at that point, simultaneously with some trade negotiations with China, the government decided to retain the lands. The Congress, knowing, and the legislative history shows this, the Congress knowing that by keeping those lands and by exercising sovereignty over them, the federal government was going to have a tremendous impact on the 11 western states, a good which of their land masses made up by those public lands. And so the National Environmental Policy Act was passed for the purpose of making sure that any agency action had to be subjected to an environmental study that included the impact on the culture, the society, and the economy of local governments that would be affected. In 1976, the Federal Land Policy Management Act was passed, and by that time, Senator Packwood of Oregon had realized that it wasn't enough just to put the word coordinate in, because people were were either deliberately or unintentionally confusing it with cooperate. And there's a big difference. Sometimes I explain that difference by explaining that when my wife and I sit down to discuss something and we're cooperating, she listens to me and then walks away and does what she wants. In our case, when we're coordinating, she listens to me and gets up and goes away and does what she wants. But if she were following coordination to the true nature, she would try to make her wish consistent with mine. That's the element that Senator Packwood put into the statute. The definition of coordination is that the federal agency must give local government advance prior notice of any regulation, any policy, or any plan that it intends to develop. Not come to local government sometime after doing it and saying, oh, by the way, here's what we're doing, but coming early and saying, here's what we plan to do, and you should be engaged in the development of it. It provides also that local government officials should be given a meaningful participation in that development. Not just sitting as a cooperating agency and listening, but a meaningful role in the development of whatever it is the federal government's going to do. The federal government is charged with the mandate of determining any conflicts that exist between what local policy is and what the federal action, regulation, or policy will be. And then the final clincher. The statute says that they must use every practicable way to resolve those conflicts and make their policy consistent with local policy. Since that statute was passed, and in the legislative history of that statute, it shows that the Bureau of Land Management and the Forest Service went to the Hill and said, Senators, this is going to make our job much harder. And Senator Packwood responded, that's what it's intended to do, because you must include the impact on local governments in what you're doing. When we started this coordination process in Owyhee County in Idaho 20 years ago, the BLM officers came in one after the other and said, well, if we do this with Owyhee County, we'll have to do it with every county in Idaho. And the answer was, every county that you deal with, yes. It didn't turn out that way because Owyhee County was the only one that tried it. And the other 43 counties continued to wonder why the ranchers were surviving in Owyhee County and not in the other counties. Every environmental statute that was passed, and they all were passed during the Nixon administration, every one that was passed used the word coordination and mandated that the federal agencies coordinate with local governments, including the Clean Air Act, including the Clean Water Act. Not only coordinate, but take into account the policy of the local government before even beginning to develop a policy, a regulation, or a rule. An act was also passed by Congress that required the agency to review any adverse impact that any policy, plan, or rule would have on any element of government that had a population of under 50,000. And if it would have an adverse impact on that county, then they had to use every practicable means to resolve that conflict. That act was put into play by Congressman Nethercutt of Washington when the Forest Service went to the Congress to get appropriations for the first major ecosystem plan, the Interior Columbia Ecosystem Plan. And Congressman Nethercutt was the last person on the committee to question the Secretary. This was big enough that the Secretary himself went to the Appropriations Committee and he said, Mr. Secretary, where is your small entity impact study? And the Secretary looked to the Chief of the Forest Service, who looked to his assistant to find out what he was talking about. And when he was told what he was talking about, he said, "Congressman, that would take us a year to do." Congressman Nethercutt, in the legislative history, turned to the chairman and said, "Mr. Chairman, I guess we'll see them next year then." And they never went back for funding. They had to try other means to get that plan in effect. And they never went back because they could not satisfy that act and still put the ecosystem plan in place. In the Endangered Species Act, the requirement is that before any decision is made as to a species, the Secretary must consider the position of any local government that will be affected by that species on the species. When the Secretary listed the Bruno hot spring snail, which was a microscopic snail that no one could see without a microscope, it was listed as endangered because a scientist from one of the California universities who liked to go to Idaho and visit the hot springs from an aquifer that has water the hottest in the nation, noticed on one of his visits a huge black spot on a rock. Was interested by the black spot, and so he took out his magnifying glass, and lo and behold, he found these little snails. He called them the Bruno hot spring snail because they were in a hot spring in Bruno River in Bruno, Idaho. 2 years later he came back, and that black spot had decreased in size by about ½ an inch in diameter. He listed the snail as endangered, and the Secretary, after study, listed it as endangered, and immediately, and this was during the time when the Cattle Free by '93 slogan was the slogan of the Department of Interior, all cows off the public land by 1993. Immediately after listing, the cows were ordered off the water, and the farmers were ordered to stop irrigating from the water in order to grow the forage for their cows for the winter. Owyhee County and the Farm Bureau went to court to challenge that on the grounds that the Secretary hadn't come to Owyhee County to determine what position the county took on this snail. And we were in fact the laughingstock of the courthouse, which is not the first or last time that we've had that position taken by the government. The Chief Judge of the Federal District of Idaho ordered the snail delisted because the Secretary hadn't gone to Owyhee County, a population of 10,000, and find out what policy they had and try to see whether he could be consistent with that. Now, we knew we only had a brief time to enjoy this victory because the Ninth Circuit, we knew, would reverse. They did not. They sent it back saying he went too far. He shouldn't have delisted it, but he should have ordered Fish and Wildlife to start over and do it right. By this time, Fish and Wildlife had grown so concerned that they had begun to coordinate with the county. And through that coordination process, Owyhee County has avoided the listing of the spotted frog, the green-spotted frog, a lizard of some type, 3 types of ants, and several other species. So each of the environmental acts that were passed had the necessity of coordination. Now, the agencies began to use every practicable means to say, well, we can't afford to do that. The Council on Environmental Quality, which was established in the White House to oversee NEPA, issued a rule that defines every practicable means as meaning unless there is a specific law that prohibits the agency from reaching consistency, then it is required to do everything in its power to reach consistency. The Council on Environmental Quality has regulations spelling out coordination, just as I've explained it, and every agency that administers those environmental laws has a rule that spells out coordination in the same way. But when you come to an agency for the first time and explain coordination, we can't do that. We've never done that before. Especially does that happen when you approach a state agency, as the City of Reading did with CARB. Well, I've talked about coordination as it applies to the federal agencies. It also applies to any state agency that is involved in a major federal action or receives federal funding. CARB's reply to the City of Reading, and I will offer into evidence subsequently in this hearing the letters that went from the City of Reading pointing out the requirement of coordination and the response from Ms. Nichols that CARB was above that law, that it didn't apply to them, and I'll put those in the record. But that position is flawed. It's flawed for two reasons. They are engaged in a major federal action regarding exhaust emissions because they are interpreting and applying the Clean Air Act, which is overseen by EPA. EPA has been giving funding to CARB to perform its duties. I'll present exhibits that show that the EPA has given grants to CARB for specific purposes regarding the exhaust emissions. I'll also be presenting exhibits that show that EPA has exercised oversight and supervision over the conduct of CARB with regard to performance under those grants, and at times has criticized them because they have not enforced it heartily enough. The Inspector General at one point in a report that I will offer in evidence pointed out to CARB that the purpose of enforcement is to be punitive. You must be punitive on the drivers and operators in order to get their attention. CARB answered to that and tried to explain that they were being as punitive as they could. But they accepted that as a concept, and we have those documents to offer that they conceded to the supervision and oversight of EPA. So not only have they received money from EPA, but they have taken supervision from them in this process. In addition to that, the other element that makes up a major federal action is that there is involved somewhere in this process a permit, a license, or a certificate. And there is, both on the part of CARB and EPA. So all three elements of a major federal action, as defined by the Council on Environmental Quality, have been met. One other test has to be met out of about a list of 15, and I'm only going to pick one. There are many more, as our argument will show at the end of this hearing, but the one that fits is there controversy over the action that is being taken? And I think we could submit 1,000 articles from newspapers and so on. We won't. We'll submit just a few that shows that this is a highly controversial regulation that CARB is enforcing. So federally, CARB is subjected to NEPA and to coordination. The Congress has defined coordination. The Supreme Court has said once Congress defines coordination or a word, then every other statute that's similar in nature, if they don't redefine the word, that's what they mean. So in every environmental statute, when they use coordination, they intend the definition, the one definition that they've made. On the California side, California statutes require CARB to coordinate. In section 65040 of the Natural Resources Planning Code of California, the legislature makes the Office of Planning and Research an important agency that serves the governor and his cabinet as staff for long-range planning and research, and constitutes the comprehensive state planning agency. And in this capacity, the office shall, there's a huge list of duties. One of the things is to oversee air quality and planning for it. The other is to oversee the environment, natural resources, and it requires coordination with local governments. So we don't have to go to the federal to find the coordination requirement, because the state requires it too. There are 4 cases in which the government has challenged whether or not coordination has been met. In the California Department of Natural Resources versus the United States Department of Agriculture and the Chief of the Forest Service, the state of California, when Governor Brown was Attorney General, sued the Forest Service because it had not coordinated with the state over a general forest plan for the 5 forests from central to northern California. And the Forest Service said, yes, we coordinated. We had 50 meetings. We took comments from the public. We had open public meetings where the local officials could have come. We asked for comments, and the court said that's not what the statute says you have to do. The statute says you have to coordinate, not take public comments. You have to coordinate and you have to attempt to reach consistency with the state. And the court set aside the forest plan because of lack of coordination. The government could have taken that appeal to the United States Supreme Court. It decided not to, and within a month they had settled with the state and were at the table coordinating. In Native Plant Society versus the city of Rancho Cordova, the California Appellate Court had a case in which the city had a plan that required it to coordinate with other agencies. In this case, in a rare situation, the federal government sued the city over the fact that the city had not coordinated with it. And the city said, of course we did. We had all kinds of planning meetings. We had public workshops. We went and we got comments, hundreds of comments from the public. The California Appellate Court gave a definition of coordination for California that's broader than the one that the federal government has put out. And in that case they said, had the city meant cooperate, they could have said so. If they know how to write the word coordinate, they know how to write the word cooperate. If they had wanted to say discuss, they could have said discuss. If they had wanted to say we'll take comment, they could have said that, but they didn't. They said coordinate. And that means come to some kind of a mutual agreement. And the city plan was thrown out. In Utah, in the federal district court, the Bureau of Land Management had a land management plan that called for putting more wild horses on the range. The county of Uintah had a plan that said we need to take the wild horses off the range because they're diseased and they're spreading the disease. They went to the district court, the United States District Court. The court said you didn't coordinate that with the county. You attempted to, you started to enter meetings, but then you didn't reach a consistent result, and so your plan is out. And the BLM plan was put aside. In the Bruno Hot Springs snail case that I've already told you about, that's the fourth and only other case where the government has challenged coordination. What I've found in my experience is that when a local government reaches the point of saying, you've got to reach that consistency with us, and the agency says we can't do that, it's against our policy, a nice, sweet letter to the Department of Justice causes the agency to call back and say, you must have misunderstood us, because we are going to coordinate. In Siskiyou County a few years ago, the supervisors decided to sue the Secretary of Interior because there had been no coordination over the destruction of the dams on the Klamath River. And the Secretary of Interior withdrew his intent to destroy those dams, saying that he would not act until or unless Congress authorized him to. Those 5 forests that I talked about that were subject to the California case were closed down through travel management plans in which there had not been coordination with the counties or the cities. And 5 of the counties in California hired me to work with their county attorneys to sue the Forest Service. And I wrote a brief that went to the chief of the Forest Service, met with he and his 2 chief planners in D.C., met with the regional forester, and he directed his supervisors to coordinate with the counties. In Texas, 4 towns, total population of 6,000, undertook to stop the Trans-Texas Corridor, which was the first leg of the NAFTA superhighway. It led from a Chinese port on the Mexican border to Oklahoma as the first leg of that superhighway, with no U.S. customs anywhere along that roadway. There had been public meetings all over the state. Thousands of people were opposed to it. The road was to be owned by a Spanish company which was going to get all of the tolls in perpetuity, own all the land along the road. And the government of Texas and the EPA in Houston was not listening to the people, so these 4 little towns engaged me and the American Stewards of Liberty to help them with coordination. The plan, the final EIS in that case, I think, I'm sure it was ready to be released when we initiated coordination. And they told us we didn't have much time to coordinate because they were going to release their plan in 3 weeks. 27 months later, the Federal Highway Administration advised the EPA director in Houston and the governor of Texas that they should withdraw that highway because those 4 little towns had made a record of lack of coordination that would beat them in court. So the governor, saying that he had listened to the voices of Texans, withdrew the highway. All based on law, not snake oil, but statutes and the 10th Amendment that underlies them. So members of the board, that's the outline of the law. That's what has to be done to satisfy the law as to coordination. Now, since the members of this board, one other thing I have to say. 2010, President Obama issued an executive order that requires federal agencies to coordinate with all non-government organizations. I don't think that was intended for the type of organizations that I represent. Nevertheless, we've used it, and we've used it to success. In places where the county commissioners could not be moved to take action to protect their citizens, non-government organizations have insisted on coordination, and the Forest Service has yielded. And the Bureau of Land Management has yielded, and EPA has yielded. So in this case, because the federal law does apply, you members of the board who represent non-government organizations have owed to you and your organizations the same duty of coordination as do the local governments that are represented on the board. Now that completes my statement as to the law. If there are any questions, all of this will be repeated at the end, but hopefully in shorter version, but I'll relate the facts to the law at that time. If there are no questions, then I would ask, since it's possible, Mr. Hearing Officer, for members of the board to present testimony as to specific matters to their knowledge, I would like to ask members of the board whether there has been coordination by CARB as to the exhaust emission regulation in accordance with the law as I've explained it. With your permission?
Absolutely. Members of the board?
Yes, Mr. Hearing Officer. My name is Gary Cadd. I'm a member of the Reading City Council, and we have sent 2 letters to CARB asking them to coordinate with us, and they have chosen to not do that in their return letters, and the letters were sent, within the last year and a half. So we have tried to have CARB come to the table and talk with us, and they have chosen not to.
Very good. Anyone else?
Yes. Bill Chappelle, Shasta County Supervisor. We had presented a letter to CARB, and we haven't gotten a response from them. So I was kind of curious for the audience, Fred Kelly Grant, if you can maybe explain the difference briefly between coordination and cooperation. Coordination and cooperation.
The difference between?
Mm-hmm.
Yes, sir. Cooperation, as defined by the courts that have defined it, and I'll take that a little step further too as to cooperating agency, because the agencies often try to push off cooperating agency onto local government. A cooperating agency is a term that the Council on Environmental Quality made up. It's not in the statute anywhere. To cooperate is to discuss in a nice, friendly manner the issues. But there is not the end result of the requirement that they attempt and make every practicable effort to resolve conflicts. That's the basic difference between cooperate and coordination. When the Congress defined coordination, they could have just used the word. And then the word, under the Supreme Court decisions, you would look to the dictionary to define the word. If you look at coordinate, it says in any dictionary you look at, it says equal, not subordinate. You look at cooperate and it talks about even-handed discussions, friendly discussions, but nothing about the equality. Congress went beyond that dictionary definition in putting in those requirements. First, that you be given prior advance notice of the intent to develop and the meaningful opportunity to participate in development. Cooperation does not give you that. Cooperation can be satisfied if they come to you and say, here's the rule we're doing, what do you think of it? Coordination does not require, or coordination does require, that the agency look at your policy and see whether there's going to be any conflict between yours and their rule as to your economy, your culture, or your social structure. And if they find one, and it's their obligation to look for that conflict. In cooperation, there is no such obligation. And if they find, under coordination, under the definition, if they find that conflict, then they have to use every practicable means to resolve it into consistency, and there's no such requirement in cooperation. So, Mr. Hearing Officer, if I could, I'd just like to go down the row and be sure that of the local elected officials what the position is as to whether there's been coordination.
Absolutely. Go ahead.
Mr. Watkins?
Yes, the City of Shasta Lake has watched the City of Redding, and while we did not formally request coordination, we closely watched the replies from CARB, and had CARB come to the city to ask us what would be our input on diesel particulate filters, I think we would have had a position that said, let's just look at new vehicles and not worry about any retrofits, and that would have been an area we could have coordinated with CARB. But they did not choose to talk to any agency or any elected body that I know of to coordinate their mandate to install diesel retrofit filters.
Thank you. Sheriff John Lope of Siskiyou County.
Yes, Mr. Grant, thanks for the opportunity for being here. I have no evidence whatsoever that CARB has coordinated with Siskiyou County officials. You know, as a sheriff, I'm primarily here, you know, because I'm concerned about the public health and safety implications, because as you know, Siskiyou County, you know, we're the 5th largest county geographically in the state. We were once a rich county because of the timber industry and you know, ranching and farming and mining and recreation, and all those are under siege right now. And you know, my concern is that regulatory provisions like these emission standards that CARB is going to enact could have a catastrophic impact on you know, ranching and farming and you know, log truck owners. I might mention that you know, during my previous life, I've got, you know, 37 years in law enforcement, and I spent 33 of those, almost 33 years, on the California Highway Patrol. At one time, I was a special services commander in 2 special divisions that dealt specifically with motor carrier regulatory provisions. And I could tell you that my experience has been in the past, especially in the North State, that a lot of our trucking outfits are small operations. And with the federal motor carrier safety standards and the California Vehicle Code and the California Code of Regulations, you know, these trucking organizations are regulated to death. And many of them have a very difficult time complying with the regulations that currently exist. So, you know, my concern is that these regulatory provisions will have a catastrophic impact on public health and safety, because when the economy, you know, right now the economy is already one of the worst in my county, one of the worst in the state. And why do people turn to a life of crime? Because there aren't decent jobs out there. They lose their livelihoods. And also, you know, from the perspective of a sheriff, I'm very concerned about, you know, constitutional provisions and the freedoms that we enjoy as Americans, you know, are under siege. And when our citizens can't even earn a decent livelihood because the lifeblood of these, you know, these type of industries are being squeezed from them, well, that means less public safety. You know, in recent years, my sheriff's department has sustained about 30% you know, budget reductions. Right now, we're trying to build a new jail. We got some funds from the state to build a new jail because of realignment. And we're grappling with this realignment and many other issues that are adversely impacting you know, the safety of our communities. And then more regulation comes in, and you know, my department gets smaller. We may not be able to build our new jail because of this regulatory provision that may shut down some of the ranching and farming and logging operations. And I could tell you that the logging has already been reduced appreciably to practically nothing in my county, and we just lost 265,000 acres in catastrophic wildland fires because of the lack of you know, forest management practices, and really the lack of this capacity of some agencies to engage in coordination, where it can ask the county, okay, well, how does these regulatory provisions impact public health and safety, your economy, your traditions, your way of life, and how you live, you know, as citizens. And those are primarily my concerns. I'll make some more comments later, but the bottom line is no, we have not engaged in the coordination process. I talked to a couple of our Board of Supervisor members yesterday, and I know of no coordination effort on the part of CARB to advise us of these regulatory provisions. And obviously we didn't give them input up to this point in time on how these regulatory provisions could adversely impact, you know, our whole county and all our citizens that we serve. Thank you, sir.
Thank you, Sheriff. Supervisor, has your county been coordinated with by CARB?
Not currently, which would be no. We had a presentation by one of the members, excuse me, we had a presentation by one of the members of the local coordinating committee, and our board had turned them down for coordination. We have written a letter to CARB with our displeasure of the new regulations. I've got a lot of comments here, but I'm not going to put those in right now. Okay. I just want to answer the direct question. Okay, is that good enough? Is that okay with you? That work? That answer?
Yes.
Okay.
Supervisor Howard from Del Norte County.
No, it is my understanding that CARB has not coordinated with Del Norte County.
Okay. Sean Curtis of Modoc County.
There hasn't been any coordination with from CARB with Modoc County. I checked with the Ag Commissioner, who's also the Air Pollution Control Officer, which you would think might be the first place they'd make contact, and there hasn't been any.
Ms. Comgick from Anderson.
I have served for Dan Logue when he was Assemblyman. I've served on a council panel with him. And my problem is that I've served 16 years on the City Council Anderson. I've been off the last 2 years, and I was elected this year to come back to the council. My experience has been that most of these people that are elected on the councils and supervisor situations don't keep up with what's going on. And Anderson does not have a coordination at this point. I brought it up before when I was on the council. And I think that they just kind of bury their heads in the sand. And one of the problems that I have is when you sit on these panels with some of these people from the state, they are totally not qualified for what their position is. They don't know what they're doing, and therefore they really don't put out any information to help you out with it. Unfortunately, I've retired now, but I had an insurance agency that insured the trucks, the loggers, and that's where I got involved with this CARB to start with. And I would say that a big problem is the state people that are running CARB.
Thank you. Ms. Plowman, your non-government organization is the California, and I always get the middle name wrong, Construction Truckers Association. Has there been coordination with your association by CARB?
No, there has not.
Okay.
No, there has not.
Mr. Smith For your non-government organization, the Reading Tea Party, has there been coordination by CARB?
Absolutely not.
And Ms. Milligan, if anybody would know whether there's been coordination with the Recreation Outdoor Coalition or Association, it would be you. Has there been?
No, there has not, and there have been problems that CARB has created for recreation. If you buy a certain type of motorcycle or quad and your husband or wife buys another, you cannot ride together on some of them because some of them can only be ridden certain times of the year, and you might be at opposite times. So it does create a problem.
And one other question, and I'm going to shorten this one up if I can. If there has been coordination by the Environmental Protection Agency with any of your governments or non-government organizations, would you raise your hand? Mr. Hearing Officer, I see none. I would presume that satisfies my inquiry that there's been no coordination by EPA or CARB.
That works for me.
Okay.